name is Catherine Hall, KATHRYNHALL. I met Ms. Abcug in the summer of 2019. We had developed a relationship after my daughter had been murdered. Cindy has been an absolute asset to myself and my family. She has put us first beyond her own issues that were going on legally. She's come a long way in the 3 years, almost 4 that I've known her. She's every year on November 17th, my daughter's birthday, that is deceased, we would collect items all year to help with the homeless. We would feed them on my daughter's birthday and hand out winter items for them, jackets and hats, and Cindy has gone out of her way to help with that. She's been there for myself and my family, like I said, during some of our worst times. There were also some of hers. I believe in the last couple of years that I've known her, she's grown tremendously. I've seen her do nothing but put everybody else before herself. Any troubles we've had, it didn't matter if it was a court date for her or what went on. In fact, Cindy had come to live with me for a short time after being released from here. And she has just, I can't even tell the courts what she has meant to all of us. And I hear what's going on today, and it's not the person that I know. The person I know has put everybody I know that has ever met her before herself. And I just wanted the court to be aware of that and what an asset she's been to myself and my family.
I'm really sorry to hear of your loss. I cannot even imagine. I'm sorry.
Thank you.
And I appreciate the information. Thank you.
Sure, I'm sorry. When I sat down, I got a message that Julia Flock didn't want to address the court. She's on WebEx.
Okay. Okay to take her at this time?
Oh, of course.
Okay. Can you take her off mute? Ms. Plotsky?
Yes.
All right. Ms. Plotsky, we are taking you off mute. Please provide information that you'd like to hear.
Sure. Thank you, Your Honor. First, I'd like to address Chris's trauma that he's had to deal with since this. Although he doesn't have any lasting physical.
Hold on just a minute, Ms. Plotsky.
Sure.
Okay. Let me do a couple of things to be sure that we get your statements properly recorded.
Sure.
Susan, I'm going to have to change the battery. I left it on, so hold on just a minute. Yeah. Fortunately, I can do that pretty fast these days. And if I can get the battery out. Okay, let's try again.
Sure. Are you ready for me?
I think we're ready now.
Great. So Christopher although he has no lasting physical injuries, what Cindy did to him while she was living with him will cause him a lifetime of trauma that we're working with him. His therapists are working with him. He'll be dealing with this for the rest of his life. In regards to the kidnapping charge, when we became aware of the threat, my entire family had to be escorted by police, armed police, picked up my children at school, drove us to a hotel where we had to stay for weeks because they were afraid of this armed raid that was going to come and hurt me, my children, my husband, and take Chris from us. And that amount of trauma that my family went through is something that I don't think 60 days will even come close to dealing with what we've had to deal with. And I think the amount of trauma that we've dealt with in regards to her associations with QAnon and other extreme groups has put my family at risk the entire time that we've had Christopher, and will be at risk for the rest of our lives. And I just think that needs to be taken into consideration.
I appreciate that. Okay, anything else you'd like for the court to know?
That's it. Thank you.
Ms. Plotke, I can only imagine what that must have been like. Being a foster parent is something that most of us think would be a brave and courageous and nice thing to do for other families who need our help. But most of us don't do it. You and your family are extraordinary. Your testimony was credible, and you and your family are extraordinary. And I wanted you to hear that from the court.
Thank you, Your Honor. I appreciate that.
Thank you. Okay.
Your Honor, just to begin with, I'll start with the kind of opposite order that Mr. Dawson did, just to address a few things. To begin with, we are asking the court for I'll start with what we're asking the court for, which is to follow the recommendations of the PSI. And we're in agreement with Mr. Dawson as far as the sentencing goes. I think we're asking for the exact same thing. We're asking for probation and have no objection to jail as a condition of probation. That said, Your Honor, just to talk about the pre-sentence time that my client has served, she was initially detained on the case December 30th of 2019 in Montana. And Mr. Hall is joining us. She spent about a month or so in jail in that time frame. She was released. I think it was actually a little bit more even. She was released. Then she was on her way here to Colorado to face these charges when she was arrested and detained in Wyoming on March 17th of 2020. She was then extradited from Wyoming here and got to our jail on March 25th of 2020. The PSI does reflect 143 days of jail, but they do calculate it from that March 25th date when she hit the Douglas County jail. So if Mr. Dawson doesn't want to credit any time that she has being extradited, totally fine with us, but we are asking the court to grant her the 143 days of pre-sentence assignment time that she did serve here. Now, Your Honor, just to delve a little bit more into that, and this court here had nothing to do with any of the things I'm going to be saying right now, but initially on a Class 5 felony with no prior criminal history, her bond was set at $100,000. It was COVID, and we were in the midst of it. We couldn't do a preliminary hearing, so she had to sit for quite a bit of time until she was actually released. But that bond was appealed, and the Honorable Judge Singer, thinking about one of the judges I used to appear in front of in Sterling, Judge Jeffrey Holmes did find that that was an unconstitutional amount of bond. It did order reduction, and Judge Bolin did reduce it to $1,000 cash for surety. So to be clear, my client sat here in the Douglas County Jail for 143 days, which we believe is an appropriate punitive sanction, given the fact that this is her first felony conviction, really her first conviction. I'll talk about the other convictions as we go through that, but this is her first conviction. To move into the LSI score, Your Honor, I did follow up with the probation officer, Ms. Sarah Hartley, on the PSI, on the LSI score, because I had concerns as to why my client, who has no prior criminal history, did score in the medium range. I thought she should have been in low range. She did advise me in an email that I'm happy to share with the prosecution or the court if the court would like to see it. If not, no big deal, but I can let the court know. She let me know that Ms. Abcug scored in the medium on the LSI by 1 point, and she scored high in the financial because she did not have at that time what they determined to be a good financial job, and that in her emotional and personal categories, those were the highest scores, which put her into the medium range on the LSI. Otherwise, she would have been in the low risk range. Your Honor, as the court knows and did note at the beginning of this hearing, my client has been perfect on pretrial. And this is that is really more extensive, I think, than maybe most people you ever have in front of your courtroom, given that she has been on pretrial since 2019. She has been perfect on that in the entirety of the hearing. This court made the determination that she should be taken off of the GPS monitoring after she was perfect for so long on that. And, I don't want to put any words in your mouth, but she was able to show you, Your Honor, and that's what this court always requires, is prove it to me that you can be compliant with my court orders, and you will be rewarded by me making changes in the conditions, including the GPS monitoring being removed, which this court made that determination on. Your Honor, both those 94 and 99 cases were dismissed. That is not to say that my client in 99, when she picked up that DUI, did not have a serious and significant alcohol problem, which is what I want to get into next, which my client for 23 years has been a leader and a huge contributor to Alcoholics Anonymous. And I know this court is extremely familiar with that group, and it has recommended many individuals partake in that group, which is I know the court is semi-limited in ordering individuals to go into it. This is in the Christian-based group, but my client is a leader there. She has two of the individuals who she currently mentors here in the courtroom. If the court would like to hear from them at all, they're more than happy to discuss it with the court. But she has attended regularly for 23 years, 3 meetings a week. She has regularly been a leader. She's regularly sponsored many individuals in that group. And one piece in the PSI, and I know that it's little, but I want to address it because I don't think that it's accurate. I think in one of the last sentences it says, if she were to continue being antisocial, that the risk levels could increase. I have dealt with many antisocial individuals being their attorney, and I believe my client is absolutely not that. She works, she goes to school, she participates in AA, she has so many community activities and community individuals who are here supporting her. See, now, a paragraph above it, Ms. Hartley does note that she does have many pro-social activities, but I just wanted to highlight that for the court. Your Honor, my client has been compliant in the DNN case, including the evaluation that the court has for it. I and Ms. Abcug decided in concert to give the court the evaluation, even though we didn't need to. And I know that it wasn't the best evaluation of all time, and she knows that it wasn't the best evaluation of all time. But the PSI recommended one, and we gave it to you because we wanted you to have all of the information the dependency and neglect case had before it. But the importance of an evaluation and the things that Mr. Dawson knows, in my opinion, are not what is contained in the evaluation, but what the recommendations are and what the treatment you get thereafter to address those issues are. We also included for the court the letter from her therapist that is based on that evaluation, where she is in therapy for the dependency and neglect case and addressing all of those issues that we have before you. And Your Honor, what you have before you is an individual for 3 years who has shown you she will be compliant with court orders. She will follow the court orders. We're not here to tell you Ms. Abcug didn't make any mistakes, because she most certainly did. But Your Honor, you don't have someone in front of you who is a threat to society, who is a threat to the community. And I will get into that in just a moment. The PSI notes that since she has been out of custody, and I'm quoting from the PSI, it appears she has not been involved in any criminal activity, has not had any new charges filed against her. She is working full-time. She has her own residence. She is actively involved in Alcoholics Anonymous and involved in numerous pro-social activities. She's employed. She's in school. We did file the transcript for the court to see that she is doing excellent in school. Your Honor, and I know the court knows this very well, I just don't know, maybe, some of the individuals in the community understand the severity of a felony conviction on your record, which she stands with. I know, like I said, I know the court knows how serious that is, but it shuts so many doors in her life. From now on, when she goes in front of anyone, they will see she is a convicted felon. And that is a huge punitive sanction. It is. It shuts doors on housing. It shuts doors on certain benefits she can get. So there is a huge punitive sanction that comes along simply with being a convicted felon who's living in our society. Your Honor, we have shown you, as I stated before, the letter from her therapist showing she is addressing all of those issues that she knows she needs to address that are from that psychological evaluation. We've gone through the letters of support and talked about that. But Judge, the issues that you have to make determinations on are really twofold. What do I do to rehabilitate the individual before me, and what punishment is appropriate given the crime that I have before you? I am not trying to minimize what has happened to any of the individuals in this case. But this court also, and I know, it makes it very difficult on you to have to treat all individuals who come before you equally. So what is the appropriate sentence? What you have, Your Honor, is a first-time convicted felon, no prior felony conviction, an individual who has been perfect on pretrial, an individual who has complied with all of the DNN requirements in her case, someone who is, this is not, when you see people who are second-time felons, the third-time felons, here on probation violation, this court, and I know your practice is, if you're going to come back in front of me on a second time, or you're not going to do exactly what I tell you on a probation revocation, that is when the serious penalties are going to be coming down, because I will be monitoring you and I will be watching you during that time frame. Your Honor, Ms. Abcug does wish to address the court. I did advise her that, you have the right to address the court or not, and sometimes when individuals have gone to trial and they wish to, appeal certain issues, they don't, but she does wish to talk to you, so I'm going to turn it over to her in just a second. But what I want to highlight is, Your Honor, continuing her in her rehab, in her treatment, in her therapy is what I believe this court should do rather than any further incarceration. So we are asking for the same thing as Mr. Dawson. We are asking for probation. We are asking the court to sentence her to jail, but we are asking the court to give her credit for time served for 143 days. Thank you very much.
All right, thank you. All right, are you ready?
Whatever you want. I go ahead.
Good afternoon, Your Honor.
Good afternoon.
I just wanted you to know that I love all my children. This is the hardest thing that I've ever gone through in my life. I know that I made mistakes. I'm sorry. But I did try my very best. It makes me very happy to hear that Christopher is doing so well, and I heard that at trial. I only wish the best for my children. I've been working hard in therapy for over 2 years, and I've been 100% compliant with this court and with the DNN court. I've been sober for 23 years and have been an active member of Alcoholics Anonymous, including the past 3 years. I currently am in school for a paralegal degree, and I'm due to graduate in December if I'm able to finish. I'm currently a cake decorator at a bakery, and I have stable employment and stable housing. I would pray that you please let me have probation so I can continue to get the help and therapy that I need, continue in my AA program, and complete my education. Thank you for listening to me.
And that is all from us, Your Honor. Thank you very much.
All right. Mr. Dawson, do you want to respond?
No, no, no.
All right, let me make a few statements that I think are appropriate, and then we'll talk about the sentence. I see things some differently than the PSI writer did. I think Ms. Abcug is manipulative. I think she, in this particular case, was so meant to be dangerous to the community, to her own son, to the Plotke family, potentially to others. I think in order to believe her version of the events, you have to disbelieve everybody else. And that's typically not the way things go. Somebody may have gotten it wrong, some doctor may have gotten it wrong, but in this case, she sees herself as a victim and continues to see herself as a victim. You are not the victim, your son is the victim. And I haven't heard a word other than you saying, I'm happy he's doing better. I haven't heard a word of accountability about the things that happened to him. I get that there's an appeal. I understand that in all of these cases, when there are convictions, that there are likely appeals, and there will be. So perhaps some of those statements are not appropriate while something is, while an appeal is being contemplated. But I started last night going through testimony, looking to see if I remembered things correctly. And just in a very short amount of time, I started to mark, and then I just quit. I started to mark the contradictions that were clearly apparent in Ms. Abcug's testimony. In order to believe that version of events, you have to disbelieve doctors, lawyers, her own children. You have to disbelieve her own children. I did not hear a single word about how painful it must have been, Ms. Abcug, for your own children to have to come and testify about the fear that you instilled in them, that your plan to go and by force retrieve Christopher illegally, that somebody might get hurt, might be their own brother, might be you in the aftermath, might be the Plotke family. I didn't hear a single word from you about the impact you had on foster family by putting that plan into place. And I look at the pre-sentence investigation and I see the recommendation and I'm stunned, honestly stunned. I would not have gone there at all. I'm not sure I will at this point. But from what I saw at trial, from what I see in these reports, and what I see in the testimonies, totally different from what they saw as the pre-sentence investigation writers. I don't know if they were provided the photos that we saw during trial of the impact, the physical impact you had on your son. It was devastating to this court to see him in the condition he was in prior to being placed in foster care. It is a delight and a thrill for this court to know that he is thriving, but he is thriving despite what you did to him. And it is unimaginable. I understand the medical child abuse constraints and what that involves. I understand that often it's not an intentional hurting of somebody, but intentional or not, you hurt him and you hurt your other children watching it. I cannot imagine that none of that was addressed in your statement. None of it was addressed to the PSI writer. I don't think you're getting it still. I'm not sure I can do anything that will assist with that. As your attorney knows, one of the things that is really important to this court and has always been is to hear what people listen to their words and really try to hear what who they are from their own words, if I can. Your testimony during the trial was without credibility completely. You were contradicted at every turn. And I can only make from that was because there were things you didn't want to talk about. You didn't want to acknowledge. You didn't want to remember. The doctors you blame made their evaluations and their treatment and diagnoses based on what you were telling them. And you had a really hard time saying that during the trial. In fact, I'm not sure you did say it. I'm not sure you said it even once. You did say on minor things, well, I told them that he had occasional seizures, but I never said it was regular or frequent, or I never said it was, I don't know, you were parsing words on it, I guess, is what I'm trying to say. I never heard what I wanted to hear, not then and not today. You've been getting treatment, you've been helping others. I hear that, and those are good things. But I still see, I think what Mr. Dawson appropriately pointed out, is you still see yourself as the victim here. You got on podcasts or websites or something and talked about the system being so broken that it was illegal. People getting millions of dollars to steal children from families. And especially interesting to you was that Christopher was disabled and they get extra money for taking him. Based on what? These individuals were trying to help your son, trying to protect your son from potentially death, because that's where you were headed with him. I have seen it. I've seen it recently in other cases, and I don't want to see it anymore. I don't know what to do, Ms. Abcug, to get through to you the things that you're not focusing on that are tremendously important in this case. The harm that you caused not just your son, but at least 2 of your other children. The harm that you caused the foster family who was only doing what they felt appropriate under the circumstances. They didn't know you. They didn't know you from Adam. They took your son in voluntarily, willingly, to care for him until you could get him back. And rather than going through the steps to lawfully make that happen, you went around the system, and here you are. I don't know what to do to get through to you. Are you helping some people? Yes, I suppose you are. But sometimes it's much, much easier to focus your attention on others rather than taking a good, deep, hard look at yourself. Pretty much easy to go and spend that time supporting and lifting up others. I would encourage you to spend 100% of your time digging deep into yourself, looking at you and why these things happened. And whether or not you can acknowledge at some point in time that you had some huge responsibility in this game. And I don't mean to call it a game flippantly. It was not a game. People were seriously injured. I will be haunted for some time, those pictures of your son and the disabilities he suffered at your hands, especially knowing that he's thriving now and that all of those were probably things that could have been avoided. I looked at some of the comments that really struck my attention when I was going through the reports and the psych eval and the pre-sentence investigation, that, well, he didn't really need to be in the chair all the time. You acknowledge that sometimes you put him in the chair while shopping so he wouldn't reach out and grab things. Okay, well, I don't know what to make of that, frankly. All of those things are upsetting. And that's just one of dozens of things. If you read and look at those matters carefully, you learn much more about a person than you expect to if you read things and listen carefully. I can tell you what my thought was before we came in today. My thought was 3 years DOC, maybe suspend a year of that, conditioned upon maybe not having any issues at DOC. I am shocked by the recommendations, a little bit put off by the recommendations. I think there is a potential, as long as Ms. Abcug continues to see herself as victimized by the system and by everybody else, that she will be dangerous again. And I don't know what to make of that. So, anybody want to address the things that I've addressed today? Mr. Dawson, Mr. O'Hanian, either one? If you don't, I'll go ahead and get sentencing done. But if you want to address any of those things, I'm happy for you to.
No. Your Honor, only to state that I do understand the court's concerns. I do. And, you know, I know you are in a difficult position, but our request would still remain that the court follow the recommendations of the PSI, of the district attorney, and our request, and allow her to continue getting the appropriate and intensive therapy. She has no objection to any condition of probation the court does see fit. But we think that given the fact that this is her first felony conviction, and given the fact that most individuals who come in front of you who are sentenced on a Class 5 felony do receive probation, we are asking the court to sentence her to the probation. And she did serve 143 days in jail during COVID. And, Your Honor, that's not an easy task. And that's not something that is simply, I know the court remembers it very well, but it was such a hard time. It was such a hard time for all of us. It was such a hard time to be in jail. And she suffered. She suffered greatly. And I'm not saying that she's a victim by any means on that. I'm just saying it was really tough, and it is a significant punishment. So we're asking the court to consider that. I know you are. Thank you.
Thank you. I also intended to say, and I will back up and say it now, I see a lot of cases. I do a felony docket every day, and I see all kinds of cases, all felonies, or mostly, I'd say 99% felonies. I rarely see the extreme and conscientious preparation that I saw in this case by both sides. I want the record to be clear. There were 5,000 pages or in that neighborhood of medical reports to review. Both sides, without any exception, had a firm grasp, and when I say that, that's sort of an understatement. Each side had reviewed every single page, word for word for word. I don't think there was a single medical report, a single issue. Both sides understood what the doctors had done, what they had said, what their evaluations were based on, and it was clear to this court throughout the course of the trial that both sides had conducted extreme amounts of preparation for this case to go to trial. I don't always say that, but this case had a lot of documents to review, and it wasn't just the pages, each individual page had multiple items to review and investigate and follow up on, and both sides did that with a fervor. I was extraordinarily pleased by the preparation both sides put into the trial in this case, and I want to thank both sides for doing that. I don't always see that, but it's meaningful to the court when you do. And with that, I'll try to move on.
Your Honor, if I may,
Yes,
do you mind if I sit since we're broadcasting?
I do not mind.
The only thing I would throw out, Judge, and I heard the court's position on this case, and I don't disagree. The only other thing I can suggest to the court is, although the court indicates that you're inclined to do 3 years DOC, which would be toward the maximum of what she could get.
I thought it was an extraordinary circumstance, and that was a 6-year term. Am I wrong?
I don't believe, because she does not have a prior criminal history, you could get to 6.
I thought the nature of the crime on child abuse heightened that to some extent,
Child abuse is an extraordinary risk crime, Judge.
but it's not the F5.
Correct.
Gotcha.
As the court is probably aware with the Department of Corrections, that since this is not a crime of violence, if the court were to sentence her to 3 years DOC, she would be immediately eligible at 50% plus good time, which takes it down to roughly 33%. That does not include recommendations of transition to community corrections, which is still considered to be part of the Department of Corrections. And I can tell the court, I sit on the Community Corrections Board, and there's people who get 7-year sentences who come before the Community Corrections Board after 9 months.
I know.
So in some respects, if the court sentences her to a term of probation, the court will actually be ensuring some greater measure of community safety, because the court can fix a more specific length of supervision, and probation can, again, keep her on GPS and will be the one recommending if additional mental health services would be out there. This is one of those rare occasions, Judge, where my concern would be if the court does sentence her to DOC, she will be back in the community, not to be facetious, but before we get home.
I guess my thought with, or at least partially what I was thinking, was that comes with the trailing mandatory parole that is also supervision. And from the court's perspective, that's a benefit. So that was the court's thought. And I appreciate Mr. Dawson, the reminder that it's not a crime of violence, so it goes 50% and then down with good time. I just think this is a disturbing and much more disturbing case than the charges would indicate. And I'm sorry that it's that way. I don't like my options very good. On the count 1, I understand, or I believe, the punishment range is 1 to 3 Department of Corrections with the trailing mandatory parole period of 24 months. On count 1, the court will impose 3 years DOC, fully suspended. That is going to be conditioned upon her successful completion of a sentence in the medical child abuse count of of 24 months county jail with all but 60 days suspended. Now, let me ask before I do this, am I creating an illegal sentence per almond by ordering it in that way?
Judge, it would be my belief, the only exception to a jail sentence in excess of what can be done, I guess the short answer is yes, Judge.
Okay.
Unless the other crime is a crime of violence or a lifetime sex offense, I don't believe the Supreme Court has carved out any other exceptions where an extensive portion of jail can be imposed or DOC can be imposed, followed by a period of probation in a single case.
And that was my reading of Allman, but I really, gosh, I think that hamstrings what the court can do.
And just for the record, I do agree with Mr. Dawson.
Okay, then let's fashion it differently so that we can still reach the same goal. 3 years DOC on count 1. That will be fully, oh, I can't do it that way either. Does it violate Allman if I impose 3 years fully suspended except the 60 days jail that you're talking about?
Your Honor, so would the court's intention then be to sentence my client to probation, DOC suspended, and then jail as a condition of probation?
Yeah.
No.
That's what I'm trying to do.
My understanding is that would be a legal sentence.
Okay.
I think you can suspend whatever you want, right? I agree. Yeah.
Okay. All right. 3 years DOC, fully suspended except 60 days county jail as a condition. And the probation term?
That's fine. Your Honor, we would really defer to the court on that. Whatever length you see appropriate, we're fine with. Given the fact that this would be a sentence that is not a stipulated one, this court would always have the ability to reconsider that even throughout the pendency, even if the probation department were to recommend
Sure.
that stuff goes great in 2 years and you want to take another look at it or something like that. So we're fine with that.
Okay. 24 months supervised probation. So we need to talk about additional terms that will satisfy the court that she is not going to be a danger and not going to decide that she needs to go retrieve Christopher by violent means.
Your Honor, I certainly do not think so. As my client has shown for the last 3 years, she is, I mean, I understand that I'm not trying to minimize the foster family. They've been through a tremendous amount. We don't want to do anything else that may put them through any more stress or anything like that. But as I stated before, she was on GPS for a long period of time, no violations. The court determined that. But if the court wants to put conditions at the, if probation feels that they're appropriate, because once again, this is a court-given sentence. I think the court can really has a lot more latitude than you do on a lot of stipulated sentences that you can't say, I'm going to give this to probation at discretion. We're totally fine if the court orders the psychological evaluation to go to probation that we filed in the case, order the conditions of the psychological evaluation because they are being met through the DNN case, for her to continue that treatment and all the recommendations that are in the PSI.
That evaluation is nearly a year old at this point.
Yeah.
So what I will impose is conditions, monitored substance abuse, including drugs or alcohol. So I am specifically ordering no marijuana use. I understand that there has been some for particular reasons, but I want to closely monitor any substance abuse, including marijuana.
Got it, Your Honor.
The psych evaluation that was provided in this case and in the DNN to probation, to be provided to probation, and within probation's discretion, if they want to require another evaluation and to follow any treatment recommendations they make.
Sounds good.
While on probation, no travel outside the state unless the court authorizes it. I want to keep a handle on that. So that'll be only with court authorization, not probation authorization. Comply with any orders of protection that are currently in place. Maintain employment, preferably full-time. If that drops below full-time, the court and/or probation should be notified with an explanation as to that.
Your Honor, totally understood and agreed upon. Would the court fashion it that it's either full-time school and work? She just got to finish up in December, so through December, it might be that she's just finishing up her school and not totally full-time, but as soon as she's done, she intends to, wants to, and will be working full-time.
Complete school.
Good, thank you, Your Honor.
Right, so, yes. And pay any outstanding fees and fines, specifically to include the GPS monitoring fees, that we got the report on. Count 2 is the 24-month probation.
For count 1, it's 3 years suspended. And for count 2, is that where you want to do the 90 days as a condition? Good deal, thank you.
All right, anything else that we need to address today?
I think that's it.
She probably ought to go stop by probation today.
She will be on her way.
All right. Ms. Abcug, please give the things that I've noted some thought.
Thank you very much, Your Honor. I know this was difficult, but,
I'm good. I wish I'd had more options.
Judge, when do you want to have her again?
She needs to remand today.
Your Honor, our request with that 143 days of pre-sentence confinement time.
I'm not going to authorize the credit. This is a new 60 days without pre-sentence confinement credit.
Understood. Your Honor.
As a punitive sanction in the case, as opposed to simply just giving her credit and calling it good.
Your Honor, I understand the court's order. Our request would be for the court to consider allowing her just a little bit of time before turning herself in. As I stated, she has been 100% compliant on pre-trial. She has numerous medications that she is on right now. We just want to make sure that all the prescriptions go down. She's just started getting another kidney stone. She has kidney issues. So our request would be for a stay of execution.
To when?
Your Honor, if the court would be willing to do a week, that would be great.
Any objection to that, Mr. Dawson?
Judge, I would defer to the court. I guess I'm slightly torn in the sense that the pre-sentence investigation report recommended jail as a condition, so she should have been prepared to go today. That said, with the court suspending 3 years DOC over her, if she fails to appear in a week, the court would have grounds to immediately revoke the sentence. So I will defer to the court.
Okay. Yeah. Okay. The court will order remand November 10 by 3 p.m.
Got it. So, in other words, she is to report down to the front of the jail at 3 p.m. To be remanded.
Yes.
And I'll remind her, as the court always does, get there a little early,